In 2016, Reliance Communications (RCOM) and Reliance Infratel (RTIL) approached the State Bank of India requesting loans worth 565 crores and 635 crores respectively, with the express intention of using the funds to repay older loans. This loan was secured by the State Bank of India with a corporate guarantee comprising of a pledge on the assets of RCIL, RCOM and RTL and a charge on the assets of Reliance Web Stores and Reliance IDC among other guarantees, as well as a personal guarantee by Mr. Anil Ambani. It was agreed that the personal guarantee would only be invoked in case the corporate guarantee fell short of the recovery amount in the event of a default. In January 2017, it was clear that the continued poor performance of the economy as a whole and that of the concerned sectors in which these two companies operated led to both RCOM and RTIL defaulting on their repayments. Declaring a debtor in the loan agreement as a non-performing asset or an NPA is a strategic move with many implications in law and is governed by a set of rules and procedures on how to move ahead with recovery. Both Anil Ambani's companies were declared non-performing assets retrospectively since the 20th of August 2016. In 2018, Anil Ambani's consult companies RCOM and RTIL defaulted on loan repayments due to Ericsson worth nearly 9.8 crores. Soon, the State Bank of India on the 31st of Jan 2018 invoked the personal guarantee by Anil Ambani owing to apprehensions created by this default. It turns out that Anil Ambani had taken out many other loans against personal guarantees without informing or obtaining the consent of the State Bank of India. These loans were taken from three Chinese banks, namely the Export-Import Bank of China, the Chinese Development Bank, and the Industrial and Commercial Bank of China. These loans too were defaulted upon and the Chinese banks began proceedings before a UK court for recovery of the loan amount. The UK court directed Anil Ambani to pay £717 million to the Chinese banks within 21 days of the order dated 22nd of May 2020. Failure to comply with this repayment schedule would empower the Chinese banks to pursue the repayment and enforce the order with any legal means at their disposal. The ramifications of this include the beginning of proceedings in the Indian courts by these Chinese companies, which could mean an attachment of Anil Ambani's assets to the loan repayments due and owed to the Chinese banks. Naturally, this would have an adverse impact on SBI's own options for recovery of its own dues, since the properties which could be used to pay the debt owed to SBI might now be attached to the Chinese companies. Hence, SBI initiated legal proceedings before the National Company Law Tribunal, the NCLAT, with two requests. The first was an interim moratorium, which is a temporary delay or suspension in legal proceedings under Section 96 of the Insolvency and Bankruptcy Code of India. The second was a request under Section 97 of the Insolvency and Bankruptcy Code of India 2016 to appoint a resolution professional who is typically an expert in matters of law and finance to oversee the recovery of the loans. Consequently, as mandated by the law, within 7 days, the court appointed Mr. Jitendra Kothari as the resolution professional. Anil Ambani's legal counsel filed against this decision in the Delhi High Court seeking clarifications regarding the Insolvency and Bankruptcy Board of India and Part 3 of the Insolvency and Bankruptcy Code. The Delhi High Court stayed proceedings and sought answers and clarifications from the centre, including those about the involvement of the Chinese banks. SBI subsequently asked to vacate the stay order. However, the Supreme Court dismissed this plea in September this year. On October 6th, Anil Ambani and his legal counsel sought to ask whether the court could involve the three Chinese banks in the CIRP or the Corporate Insolvency Resolution Proceedings. Thereafter, the Delhi High Court sought the views of the Supreme Court and the centre on this issue. Two kinds of debts are allegedly owed here to the State Bank of India. One is a corporate guarantee on the behalf of Reliance Communications and the other is a personal guarantee on the behalf of Mr. Anil Ambani. Both parties agree to the first kind of debt and to that effect agree to CIRP proceedings, but the parties disagree when it comes to Mr. Anil Ambani's personal guarantee, which the SBI believes him to be liable for, whereas Mr. Anil Ambani contends that this is not necessary. Earlier, when the two loans had been defaulted upon in 2017, the SBI had not taken any legal action. but only sent in a demand notice, which too was filed only when Ericsson filed a petition in 2019. Eventually, it was withdrawn. On the hearing dated 28/2020 before the NCLT, SBI, being the applicant, fought for the appointment of the RP, and Anil Ambani, the respondent, opposed the invoking of the personal guarantee as a whole. Anil Ambani argued that the amount that the SBI would get from the CIRP of RCOM and RITL and its other corporate guarantors would be sufficient for the loan's repayment. His lawyer stated in a letter dated 13/3/2019 with the ongoing CIRP of RCOM and RITL that the liabilities under the resolution plan approved under the code pursuant to which the personal guarantee will be rendered redundant, more so in the view of the understanding that the personal guarantee would not be invoked until the other guarantees had been. They further argue that the UV Asset Reconstruction Company Limited has submitted a resolution plan in the CIRP of RCOM, and the Reliance Digital Platform and Project Services has submitted a resolution for RITL. The resolution professional applied for approval of the resolution plan of the UV Asset Company Private Limited. The Committee of Creditors approved the plan unanimously. They argue that the resolution plan of UV Asset Reconstruction Company Private Limited should be able to discharge the entire financial debt of RCOM to the Committee of Creditors. They suggest that the recovery from RCOM would be approximately 31,000 crores, which is the entire secured debt of the Committee of Creditors. They add that the resolution plan of Reliance Digital Platform and Project Services Limited would take care of the entire debt of RITL. According to a report by Business Standard, UV Asset Reconstruction Company Private Limited bid 14,000 crores for spectrum, real estate and other assets of RCOM. And Reliance Digital Platform and Project Services would pay 4,700 crores for RITL's tower and fiber assets. The Chinese banks would receive 5,500 crores from the CIRP. For the situation with the Chinese banks, they state that due to the petitions filed on 12/3/2020, the interim moratorium for RCOM and RITL has come into existence due to its CIRP proceedings, and the Chinese banks would be restricted from enforcing the UK court order in India. They believe that there is no urgency in the matter of appointing an RP for Anil Ambani. To support their arguments, they state that the NCLT opined that once the debts have been assigned to the creditors, the guarantees would cease to exist. And in addition to that, the tribunal maintained that once the resolution process has been initiated against the corporate debtor, the same claim cannot be filed by the creditor against the guarantor. But it is important to note that these cases are still pending appeal. They suggest that appointing an RP for Anil Ambani would be premature. They ended their argument by saying that if the applications were allowed, Anil Ambani would face grave prejudice, irreparable loss, injury, and loss of reputation. In their submission, SBI has boldly argued that the suspension of present proceedings would be an anathema to the schema of the code. They say that it would affect the provisions under Section 62, 95, and the 97(3) thereof. They relied on Gauri Shankar Jain vs Punjab National Bank 2019 and the State Bank of India vs Ramakrishnan 2018. The Gauri Shankar case was used to oppose the argument of Anil Ambani regarding the personal guarantee being extinguished if a resolution plan is approved. The judgment of the case was that the liability of a guarantor of a debt of a corporate debtor does not go away if an insolvency plan has been approved under the code. The Ramakrishnan case was used to counter the argument of Anil Ambani regarding the interim moratorium of corporate debtors. This case held that the period of moratorium under Section 14 of the code did not extend to personal guarantors. Section 62 of the Insolvency and Bankruptcy Code provides for simultaneous proceedings against the personal guarantor. They stated that the law does not suggest that the CIRP of a personal guarantor should happen only after the CIRP of the corporate debtor. Thus, to counter the argument made by Anil Ambani of not enforcing the application, SBI says that if the law allows the submission of an application, and if the application has been submitted, it would be wrong if the NCLT does not act upon it. SBI then added to this, stating that the NCLT can proceed against the personal guarantor under Section 62 with Section 95 and Section 97(3). The Section 95 of the Insolvency and Bankruptcy Code 2016 mandates that Section 95 and 97 of the code are to be read along with Section 62. The purpose of these sections is to smoothen the filing of these petitions. SBI states that they have filed these petitions under 95(1) of the code and read with section 97(3). They requested the NCLT to approve the RP themselves, as the IBBI, with Rule 8 of the INB Rules 2019, has shared a list of insolvency professionals for the purpose of 97(4) of the code. The board does not need to nominate an RP, and the NCLT can appoint one from the list themselves. The court ruled in favor of SBI, appointing Jitendra Kothari as the RP, and a moratorium was issued for the CIRP of Anil Ambani. The NCLT also opined that Anil Ambani's defense did not raise the point of their credit facility being deemed as an NPA before the loan agreement was signed. On 27th August, Anil Ambani filed an appeal with the High Court. Anil Ambani's petition was also challenging the legality of the personal insolvency provisions against personal guarantors under Part 3 of the Code. The provisions under the Code, which only covered companies earlier, but as of 15th November 2019, the Part 3 of the Code was brought into effect. Part 3 covers personal guarantees, promoters, and the insolvency proceedings against them. In the hearing, Anil Ambani's counsel referred to the case of Mr. Lalit Kumar vs. Union of India, Ministry of Law and Justice and others. They claimed that their case was ultra-vires under Part 3, Chapter 4 of the Code. Chapter 4 of the Part 3 of the Code states that proceedings for personal bankruptcy of the personal guarantor. As this inclusion is new, there are many questions regarding the same. Lalit Kumar challenged the validity of Part 3 of the Code. Lalit Kumar's case was given a stay order by the court, challenging the legality of Part 3 of the Code. Thus, based on the fact that the Lalit Kumar and Ambani cases are similar in nature, on the 27th of August 2020, the HC of Delhi issued an order stating, the proceedings would continue in relation to the corporate debtor, and while dealing with those proceedings, the liability of the petitioner may also be examined by the IRP. However, the proceedings against the petitioner under Part 3 of the IBC shall remain stayed. We restrain the petitioner from transferring, alienating, encumbering, or dealing with or disposing of any of his assets or his rights or beneficial interests therein till the next date. The order was sent to SBI, Central Government, and the Bankruptcy Board of India. The date of the next hearing was set to 6th October 2020. The senior advocate of SBI opposed the stay on proceedings under Part 3. They said that this would stall many similar cases, and the object petition was done to derail the established process under IBC. On 27/9/2020, SBI filed a plea in the Supreme Court where they dismissed SBI's appeal, which was to vacate the stay order granted by the Delhi High Court on the bankruptcy proceedings against Anil Ambani. On 6th October, the Delhi High Court ordered the Centre and the SBI to send their replies on the matter of the inclusion of the Chinese banks in the CIRP proceedings.
They have also asked the Centre to comment on their thoughts on Part 3 of the Code. As mentioned above, the reason to include the Chinese banks was to make sure that Anil Ambani does not fall in contempt of court if he complies to the order given by the UK courts.